Lawyers, what's the most obscure law that you've actually used in a case? One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him but doesn't turn on their headlights. Eventually, they pull the man over and find that he has a lot of substances in the cab of his trunk. Charges are brought for possession with intent to distribute. They go to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle. Because a police officer was also driving without headlights, the man had no reason to see them, and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of these substances was fruit of the poisonous tree, quote-unquote, i.e., any evidence that is discovered improperly must also be excluded. Case dismissed. Wow, I hope that guy paid his attorney pretty well because that attorney just got that dude out of some serious prison time. Story 2. My maritime law professor was a glorious schmuck, and I'll never forget his story he told us. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club are right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded. So he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member, but because he was in the public access section of the beach, legally, they couldn't do anything. Story 3. I had to give advice to a public entity about the U.S. flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer? None. Petty, upset employees got no satisfaction. Story 4. I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery, or misplaced cargo, but provided coverage for all non-excluded losses. They tried to argue that in misdelivering the cargo, they had lost it, and thus it fell under the policy as non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost. But they still tried to claim that a quote-unquote loss in an insurance contract included anything quote-unquote lost. Dumb as crap argument, but the partner took out my entire section addressing the definition of loss as in to lose, and loss in an insurance context as in the monetary value of insured property, and we lost the MSJ. I'm thankfully no longer in commercial property insurance defense, but that one really annoyed me because it was such an obvious mischaracterization of the contractual language and such a stupid move by the partner. Story 5. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. Story 6. Obligatory, not a lawyer, but I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification of many that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently, nobody did, though nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. Story 7. Not exactly a law, but if there's a no-deal Brexit, all kinds of old treaties between European countries and the UK kick in. I know some countries are already proactively retracting old treaties to prevent weird or unwanted stuff from happening. Can give sources, but can't find them in English this fast. To make things more complicated, French, Belgian, and Dutch fishermen have a lot of boats under UK flag and using UK fishing quota and permits, as those were easier to get some time ago. But in practice, they sell their fish on the continental market. How will this hold legally after Brexit? Depends on which old treaties are still active. Story 8. I do remember hearing a story where this guy in Michigan was arrested for underage drinking but was only a couple of months away from turning 21. He went to court and pulled out a termination law from Michigan stating that, quote, life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed, and when the prosecutor made a stink about it, the guy said, hey, it's your rules. Oof, that's my favorite one so far. Story 9. When I was in college, a girl who worked at an expensive law firm told me this, and I always wondered if it was true. She said that when Oklahoma passed a new intoxicated driving law, that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one, most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. Story 10. I'm no lawyer, but there's a case that took place in the UK court, Her Majesty's Revenue and Customs, HMRC, versus McVitie's. McVitie's make a biscuit called Jaffa cakes, and HMRC argues that they were a biscuit and subject to taxation. McVitie's argued that they were in fact a cake, and cakes aren't subject to taxation. McVitie's made a bigger version of a Jaffa cake, cake size I guess, and argued that cakes go hard and biscuits go soft. The Jaffa cake went hard and McVitie's won the case. Story 11. When I was 13, I was arrested in Portland for spitting. Apparently somewhere in their old law book, spitting on the bricks was against the law and they went with it. Handcuffed, thrown in a car with lights and sirens, I was booked at the station. I could hear my mom screaming at everyone she talked to, armed or not, about how stupid they were. It was one of the only times I felt my mom had my back. They dropped the case when she started offering interviews to the local news stations, but I still hold on to my citation for a good laugh. That was 19 years ago, for reference. Story 12. Not a law per se, but a couple of times when the other attorney has really made me mad, and once with a close friend who I feel like messing with a little. I've responded to an essentially unreasonable request, or in the case of my buddy, an eminently reasonable request, by referring them to the reply given in the case of Arkdell versus Pressdram. No one ever knows what it means until they Google it. Case is below, reading to the bottom is totally worth it. Arkell versus Pressdram, 1971, unreported, solicitor, Goodman, Derrick & Co. We act for Mr. Markel, who is retail credit manager of Granada TV Rental Limited. His attention has been drawn to an article appearing in the issue of Private Eye dated 9th April 1971 on page 4. The statements made about Mr. Arkell are entirely untrue and clearly highly defamatory. We are therefore instructed to require from you immediately your proposals for dealing with the matter. Mr. Arkell's first concern is that there should be a full retraction at the earliest possible date in Private Eye, and he will also want his costs paid. His attitude to damages will be governed by the nature of your reply. Private Eye. We acknowledge your letter of 29th April referring to Mr. J. Arkell. We note that Mr. Arkell's attitude to damages will be governed by the nature of our reply and would therefore be grateful if you would inform us what his attitude to damages would be, were he to learn that the nature of our reply is as follows. Screw off. Story 13. I recall reading a case file once where a girl was intoxicated and was kicked out of a club. An intoxicated male sees her passed out in the street, whips out his giggle stick and puts it on her head and takes a picture. She sees the picture and claims for SA. However, the lawyer argued there were 4 points of SA. Needs to show a Johnson, needs to perform an act which humiliates the victim, another I forget, and finally needs to show intent. However, the defense argued the defendant didn't show intent as the picture clearly showed he didn't have a and he was let off the charge. Story 14. It's obscure case law, not a statute. A coworker of mine used a court decision from the 1880s to successfully defend a document someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read but had a slight smudge that the other side argued made it invalid. They were able to keep the document out in an administrative hearing and won the case on that level. Based on that, we appealed it to district court. My coworker found the case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case you could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision. Story 15. In its entrance application, the National Sheepdog Association, which sponsors the annual National Challenge Sheepdog Trials, requests the name of the animal that would compete. And so it was that former Hoggett was able to honestly answer pig. When confronted with the indignation of the competition's judges at the enormity of his porcine injury, Farmer Hoggett's defense simply was, there's no rule. The judges had to concede that there was indeed no rule precluding the little pig from competing. And while the announcers and the crowd were bemused at the appearance of Farmer Hoggett and the little pig in the arena, all were overjoyed in the end when, without the least trouble, the little pig turned in a perfect performance and won the day. That'll do, pig. That'll do. Story 16. It's quite common that a jury will convict a guy, but the conviction is overturned because the prosecution didn't present sufficient evidence of one of the elements of the offense. In an extremely rare version of this legal principle, my brother-in-law just had a case where the prosecution will forget to present evidence proving the crime took place in the geographic jurisdiction, like a county or state of the court. Jurisdiction must be proven like any other element of a crime. The closest they got in this case was someone's testimony that it happened at home. Conviction reversed, defendant is free to go. Story 17. When I clerked for my judge in law school, he told me a story about how the case before him involved a homeowner attempting to invalidate a restrictive covenant on his property that contained the restriction of no animals to be raised on the property. Said homeowner had chickens or some other livestock and was being fined on the basis that the plain reading of the covenant required that it be invalidated on public policy grounds that it prohibited homeowners from procreating and raising children. Story 18. Just knowing the rules qualifies a lawyer as knowing obscure law, since most lawyers don't bother to read all of them nor memorize them. Let's go off the record. No, I refuse, Madame Court Reporter. Continue taking everything down. I'm paying for the court reporter. I own this deposition. She'll stop when I say stop. Well, actually, the rules of judicial administration and civil procedure both deal with the qualifications of a court reporter in this situation, and the rule specifically states that no one shall go off the record unless both parties consent to it. Here is the rule. Oh. Story 19. My sister's story. She was helping a teen who got in a minor car accident but still had to show up to court. The other side decided that he wasn't getting punished enough, so they tacked on a law from the 50s that anyone under 18 couldn't use a washer and dryer, completely unrelated to the original case. The teen admitted to it when questioned. The judge agreed and sent the poor boy to juvenile hall for 3 months. He was only supposed to get his driver's license suspended. Story 20. Not a weird law, but a badly written contract, if this counts. I had a friend who entered into a contract where one party contributed the down payment for a new house. The other would live in the house and make monthly payments, and then they'd split the gains, subject to a formula when the house was sold. The housing market tanked and the latter party bailed, forcing the sale of the house as stipulated in the contract. Because the contract didn't mention losses, the party who paid the down payment on the house got screwed. Story 21. In 1976, somebody found an obscure Texas law that states that every company in Texas that sells beer or alcohol, 51% of that company's stockholders must live in Texas. I was working at Pizza Hut and Texas Liquor Control walked in and yanked our license and stopped us from selling beer. This went on for several months until a Texas lawyer figured out a way around it. His name was Gerald L. Anderson, and he set up a company that sold beer inside the franchise Pizza Huts in Texas. At night, when we made the cash deposits, we had one for Pizza Hut and one for Gerald's company. Pretty damn smart. Story 22. Recently, someone filed a motion based on champerty and maintenance in one of my cases. These are common law doctrines that basically say you can't transfer your right to sue someone without also transferring whatever gave you the right to sue. For example, if I want to sue a mechanic because he did bad repairs to my car, but I don't have the money to sue, I can't transfer my right to sue to my rich friend without also transferring the car. Without getting too technical, I believe it's rarely used because it's already covered by the real party in interest requirement for standing. It's like insisting on saying "milady" instead of "miss." The person who filed the motion tends to file a lot of weird stuff that they don't understand, this one being no exception. Story 23. Have an ongoing case on the issue of ademption and its exceptions. Ademption is basically a rule in estate law that if a gift under a will, typically property, is no longer owned by the departed at the time of passing, then the gift is adeemed, meaning that the person who is given the gift gets nothing. There is basically a big fight over the money from the sale of the house. The person who was given the house under the will wants the money from the sale of the house, even though the house itself is the only thing that was gifted and is no longer in the estate. The main problem is there is basically no law on this in my state. There is one state Supreme Court case that discusses ademption and possible exceptions and no other cases applying the exceptions discussed. So we are relying on interpreting this case as well as cases from other jurisdictions, which, as lawyers will tell you, if the case isn't binding on your court, you don't typically use it or discuss it, but you have to use what you can find. Story 24. I dated a woman for about 5 years. We broke up, but I didn't move out because even though we were not quote-unquote together, it was advantageous for both of us to continue to live together, combined income and a few years of friends with benefits situation, and I moved into the spare bedroom. I basically started paying her rent for the room each month to help with bills. One night, cops show up with a search warrant looking for one of her kids' friends. Now this made me mad because 1, I have severe insomnia. 2, they came in at about 2 a.m. 3, the warrant was signed at around 1 p.m. 4, I had just fallen asleep when they came knocking. This royally made me mad because there is one thing you don't do, and that is mess with my sleep. When they asked if they could search the house, she said sure because we knew the kid wasn't in the house. But remember, they made me mad. I reminded them that as a rent payer and that my room was not a public traffic area, that legally they needed a separate search warrant to go into my room. I let them stand in the doorway with bedroom lights off, using a flashlight to look into the room. Now, had they not made me mad, however, I would have let them know the kid was not in the house. He was in the clubhouse in the backyard. They never checked the backyard. Note, only reason, besides making me mad that I was not forthcoming with where he was hiding, was due to knowing what he was accused of was a false claim, and the next day I managed to get video proving it. They ended up throwing the case out once I got the video to the DA. Story 25. Not a lawyer, but a land surveyor. You would be surprised how much of the United States law concerning land ownership has its roots in the old feudal system and English common law. Most land that is freely bought and sold is said to be fee simple. In the Middle Ages, if you performed service, your fee for the crown or your lord, you could be granted land that you could freely sell to someone else. Other kinds of deeds also date back to this period. A life estate was one that would revert back to the grantor upon the passing of the grantee. Lastly, a fee tail is land that can only be transferred by inheritance to a male heir. Fee tail has been struck down by U.S. courts and is no longer enforceable. Story 26. I'm not a lawyer, but I was working for the Attorney General's Department in Australia as a computer nerd doing a proof of concept website for Australia's Personal Property Securities (PPS) law, basically getting loans and liens against things like paintings like you can for a house or a car. We were using other Commonwealth countries' laws as a basis for the draft Australian law, mostly focused on Ontario. A number of paralegals were at a desk behind me discussing the Ontario law, and it was a logical fallacy. In simple terms, the law states that A is greater than B, is greater than C, is greater than A due to a lapsed then re-registered lien during a grace period. Ontario's Personal Property Security Act, RSO 1990, Chapter P.10, Section 36. After diagramming it out for the paralegals and again for the head lawyer for the AG's department, there was about a week and a half of intense discussions between the Australian and Canadian legal teams. So, I'm the reason Australia's PPS law doesn't allow for re-registration grace periods. Story 27. Had a professor in my undergrad economics program who was defending a serial criminal. The guy would order pizza from a delivery place to a hotel, rob and end the drivers, left no evidence in the rooms apart from one. In one, he took off his gloves to take a dump, left a fingerprint on the inside of the roll that he changed. The professor was clueless on how to proceed and actually asked our class for advice on possible strategies. No one had anything remotely helpful, guessed that there wasn't much of a defense offered. Story 28. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over, cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car, asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently, the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. Story 29. I have one where we won but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates who couldn't work with pigs were offered to be able to work as the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs or didn't want to would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. And if you're enjoying the video so far, don't forget to hit that subscribe and like button for more videos just like this. Story 30. Had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond executed by the individual defendant or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond without the corporate signature. There's no question in my mind that they had the bond with the requisite signature and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. Story 31. Not a lawyer, but I got a charge drop because the cop's bad handwriting. I got a ticket on a Monday night for speeding and was driven a court date of like 2 months from then. About a week and a half later, I got a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that and tell the judge not guilty on the FTA and no contest on the speeding. After asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, "You have a point there, not guilty on the failure to appear. And how do you plead for the speeding charge?" I replied, "No contest, I was speeding, Your Honor." He looks at the ticket, sees that the cop had initially put 10 over and in the notes put my actual speed, like 20 or 30 over, and goes, "Yes, it certainly looks that way, LOL. Story 32. I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will if we won than she would with it if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's departed mother, but that will had been revoked. We found a very old doctrine and a footnote to something else entirely and argued to the judge that the law assumes you'd rather pass away with an old revoked will than with none at all. Therefore, we argued that he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had standing to bring the will contest. We ended up settling the case shortly thereafter. Story 33. I once got out of a parking ticket by refusing to admit I was the driver. In the UK, parking companies that use automatic number plate recognition can get the contact details of the registered keeper of a car from the DVLA or DMV and send them the fine in the post. But I did some Googling and found out that legally it's not the registered keeper who is liable for the fine. It's whoever was driving at the time. This isn't always the case. There are situations where they can hold the keeper liable, but in my specific case, this didn't apply. They really don't like you knowing this. Their letters are worded very carefully to give you the impression that you are liable for the fine as keeper of the vehicle, without ever actually outright saying that, and they do the crap where you can either pay a reduced fine now or appeal and pay a bigger fine later. I appealed. I didn't lie and claim I wasn't the driver. Instead, I just pointed out that they are contacting me as the registered keeper, that the registered keeper isn't legally liable to pay the fine, and that I am under no obligation to give them any details of who was driving at the time. It took months and 2 appeals, but eventually I won and didn't have to pay the £20 fine. I would have paid, but I felt like I hadn't done anything wrong. I'd not parked illegally or over time or not paid or anything. I just forgot to validate my parking after shopping at Tesco. Story 34. I'm not a lawyer, but I got my case for a reckless operation of a vehicle thrown out, dropped, forgotten about it, I don't know what to call it. I was younger and was one of those kids with a loud muffler driving all over the place. Eventually, it caught up with me and I got 3 major speeding tickets, 30 plus miles per hour over the limit within 30 days, which is an automatic summons for reckless operation. I arrived at court and waited as they called people up and handed out punishments. After hours, everyone had left and the state officer walked up to me and asked why I was here. I presented my summons slip and he had no record of it. We went to the office and it wasn't even on the computer. They gave me a new one and told me to come back in 90 days. Lo and behold, in 90 days, for some reason, it still wasn't in the computer. It was as if I was never pulled over at all that final third time. The officer must have slipped up and forgot to submit some kind of paperwork. They tried to give me another one, but I put up a stink saying that I had held up my legal obligation not once, but twice, and I was going to get a lawyer involved. They slapped me with a $100 fine and sent me on my way without any further repercussions. Biggest bullet I've ever dodged thus far. I would have likely lost my license for some amount of time. Chances are with a lawyer, I wouldn't even be fined, but that was too much hassle. Besides, I had broken the law and I deserved a fine at the very least. Story 35. Whoa, I'm not a lawyer, but when I was in high school, my friends and I used to flour bomb cars. Yes, this is stupid and you should not do this. Pour a half cup of flour into a damp paper towel, twist into a little sack and tie it off with a rubber band. Throw it at someone or something, poof. I was caught by police and given a fine of $360, the maximum allowed with what I was being charged with. I contested it because I was broke and figured the officer wouldn't show up to traffic court. The language of this law was oddly specific. I was charged with throwing or placing a dangerous or injurious object in a roadway. If the language had been left at this, it would have been pretty easy for them to enforce this and I would have had no choice but to pay. I also want to be clear that I definitely did something stupid and could have hurt someone. I deserve whatever was coming. But the law went on to define with strange specificity what constituted a dangerous or injurious object. It included things like rocks, pine cones, plates, tires, and on and on and on, but nowhere did it say anything about flour or food or paper towels or rubber bands. The room was divided into normal traffic violations like speeding and whatnot, and then other. Myself and one other person were the others, and we got to go first. I had no idea what I was doing, but when it was my turn, I got up in front of the court and pulled out a law book and read this, and then presented a flour bomb I made and made a nervous attempt to explain why I didn't think this met their definition. The DA and the police officer who gave me the ticket had an exchange and then spoke with the judge for a minute. They did not look at all that concerned nor pleased, but after a minute or so, the judge said I was free to go and that the fine was dismissed. A few people started laughing and a bunch of people clapped, which I must admit felt kinda awesome. Again, this was a dumb thing to do and not exactly in the spirit of the law. I was a turd and got away with it. Story 36. I had a client with a serious medical problem that cost her her job, and she was preparing to file bankruptcy on the medical bills and credit card debts. Thing was, she had like $15,000 socked away and didn't tell me. It was all that was left of her life savings. Before we filed her case, she gave it to her mom for safekeeping. What she didn't know is that she could have kept the money through bankruptcy, but giving it away beforehand is a no-no. I had to tell the court when I found out, and when this happens, the court gets the right to sue the mom for the $15,000. The thing is, the mom's debt to her daughter's bankruptcy court also dischargeable in bankruptcy, so the mom filed bankruptcy too and then got to keep the money after all. Story 37. Not a lawyer, but we were talking about NCAA rules for cross-country running once, and we focused in on the rule that said the runner needed to have at least one shoe on when crossing the finish line. Apparently that rule has been changed now because 2021 rules say barefoot is okay. A few weeks later, I was running in a separate race and I had a bit of debris in my shoe that was causing immense pain. So I ripped the one shoe off and kept running with one shoe on, knowing that I needed to cross the finish line with one shoe on. I didn't win the race, but I had one of my best times and beat our best runner. Running can be a psychological thing, and running half barefoot somehow motivated me and demoralized him at the same time when I passed him carrying one of my shoes. Story 38. Mandatory, I'm not a lawyer. I did beat a traffic ticket based on a poorly worded ordinance and arguing it to the prosecutor. I was charged with approaching a parked public safety vehicle displaying its lights, which basically means I didn't move over a lane when a police car was on the side of the road. The problem was, I was on an on-ramp. There was no lane to move over to. The cop was just smuck and told me I was trying to end him and told me to pay the ticket or go to court and pay more. I read the text of the ordinance he cited me violating and saw the phrase, or other prudent action based on road conditions and driver's judgment. Surprisingly, the key word is and. I just so happen to know that in my state, the word and in legalese can also mean or. This was my very first citation ever with a spotless decades-long record. I chose to go to court and argue my case. When I arrived, I was put in a pool of people who had tickets to argue and called up one by one to talk to the public defender. When it was my turn, I said I would like to speak to the city attorney. They were very confused and asked if I was Mr. Huabak's attorney. I assured them I was actually Mr. Huabak's. I informed the city attorney that the ordinance was written in such a way that handling the situation with the cop on the side of the road was up to my judgment, and I decided that I handle the situation in a safe manner. He looked at the text ordinance and then looked at me and gave me a look of, I can't believe he's right. He dropped the charges. Later that year, the city cleaned up their traffic code and changed the ordinance to make the ordinance end based on a combination of the road conditions, traffic flow, and judgment of a similarly skilled motorist, or something close to that. Story 39. I used to haul produce for my neighbors who had a small vegetable farm to the farmer's market and then sell it in the mornings and come back in the afternoons. On Memorial Day weekend, coming back from the market, they had a DUI checkpoint in the afternoon. I didn't have my driver's license with me because I had forgotten my wallet that morning when I left, so they wrote me a ticket for not having my license. But they wrote the ticket to the owner of the truck, not to me. When I got to court, I was standing in line next to the cop, and right before we walked up to the judge, I whispered, I'm gonna get out of this one, and he just looked confused. I then explained to the judge what had happened, and that was obviously not the 67-year-old truck owner the ticket had been written for. The judge looked at the cop with utter disdain and dismissed it. Story 40. My mom was getting sued by a debt collection company that was well known for suing people as a means of threatening them. I had some time and I looked up the laws on debt collection. Where we lived at the time, you had the right to demand in writing that they provide evidence that they actually hold the debt, and they had a certain amount of time to respond under the law or they forfeit any right they had to collect said debt. I sent them a certified letter. We never heard back from them. When we went to court, I submitted the receipt for the certified letter and said they had failed to provide the proof within the legal time frame and cited the law. Case dismissed with prejudice. The lawyer for their side didn't even care. Story 41. Contrary to popular perception, the legal system does not involve a hunt for some arcane law that lets you win this with one simple trick. The closest I have ever come to that, and it was a complete aberration, was a complex dispute over the validity of a mortgage note with the bank. One of the issues was whether there was sufficient consideration, something of value, exchanged for the note. I dug up an old case that said if the mortgage contract was sealed, consideration was presumed. And sure as crap, the contract had seal written after each of the signatures, so that resolved that particular issue. But then there were a whole bunch of other allegations of fraud and self-dealing to sort out. 90% of legal cases involve credibility disputes between witnesses about what happened, not finding some magical Harry Potter type Latin spell to utter in court. Story 42. Happened to me when I was a teenager. My friends and I bought some beer and then went to a high school football game the first week of my senior year. We obviously got caught, and all 6 of us got tickets for underage possession of alcohol. I was a DD and had been driving my dad's Suburban with our very unique last name on the license plate, so it was really easy to figure out whose car it was. Went to court a few months later, the ADA presented her case, cops testified, they even brought the alcohol in as evidence. Right after she rested her case, my attorney stepped up and asked the judge to dismiss the case. We were all very confused. The judge looks at the ADA and just kind of shakes her head and agrees. My attorney explained later that she forgot to prove that we were under 21, so there wasn't a case anymore. I've never been so glad for a technicality in my life. Story 43. We purchased a motorcycle at the beginning-ish of the year. DMVs are horribly backed up, and we got an appointment as soon as we possibly could to get plates and registration. Day of the appointment, we are very excited to finally have everything legally registered. We got a VIN verification, which didn't take as long as we thought, so we thought, let's go grab some lunch. We parked and paid for parking and then came back with a ticket for no plates on the vehicle. The officer wrote the ticket for a city ordinance that states it is illegal to drive, park, etc. any vehicle that has been assigned a license plate or plates without having a plate attached to said vehicle. Great news, I haven't been assigned a license plate. Ticket dropped. Story 44. Early in my career, I had a fairly minor case in which my client's neighbor cut down a bunch of shrubs and small trees bordering their properties because they blocked his view. This really irritated my client as he wanted his privacy. Now, the monetary damages were actually not that much, and this was looking like a case that really couldn't be economically litigated for what the client could afford. However, in researching the issue, I found a rather obscure law that provides for attorney's fees to a winning plaintiff when a defendant has willfully damaged the border foliage of a ranch or farm. In looking up the definition of these terms, I realized that my client's property actually qualified for the statute as he used his land for growing a variety of produce for market. Once attorney's fees were on the table, the other side quickly caved and wrote a big check to cover the damages. Story 45. I had my personal truck towed from a Walmart parking lot for being illegally parked. This made me so angry, so I decided to look up and read all the parking and towing laws in Ohio. After reading said laws, I called the towing company that was responsible for what I assumed to be an improper tow and informed them of their mistakes. 1. There weren't signs stating the proper information, like no parking, name of towing company, etc., at all entrances to the parking lot. I went back and checked, and the entrance I used did not have a sign. I also made sure to take a video and pics. 2. I contacted the local sheriff's office and some other office, forgot their name, and both said that the towing of my truck was never reported. There's a specific law that says if you tow a vehicle, you have to take pictures and let the local facilities be aware of the incident within a certain amount of time, like 24 hours or something. 3. The location of their lot where they towed my vehicle to was further than 30 miles away from the Walmart. It's law that it is within 30 miles. They were like 31, 32 miles away. So after explaining this to them pretty damn well, and after receiving a lot of negative comments about how they've never dealt with anyone like me before or how much of a schmuck I am that I should just pay the $150, I threatened them with litigation. I said I could take this to a small claims court and sue them for 3 times the amount I would have lost, at least 3 times $150, and the poor guy who towed my truck could get slapped with a misdemeanor. Needless to say, they caved and told me I can just come pick it up whenever for free. They put up a sign at the entrance I used within a week and probably started following the laws after that, lol. Story 46. Not my case, but a case my office handled. In Belgium, a break-in during the night is punished more severely than a break-in during the day. The question then is, when does the night start? The night legally starts at sundown and ends when the sun comes up. This was before the internet was mainstream, and basically every household had the same calendar. You could pull the day off, and there would be some information on the day, month, the moon, and the sun, the patron saint of that day, and maybe a joke. Like this calendar was known by everyone as the standard calendar. The prosecutor used a date on the calendar to state that the sun went down on the day of the break-in at 21:36 hours, or something like that. So since the break-in was caught by the police at 21:3800, the more severe punishment was in order. I found it really stupid that the guy had a more severe punishment for 2 minutes, so they started looking and came upon the Belgium Royal Stargazing Observatory, who are the legal association to record weather and things like that. So we wrote them a letter asking at what time the sun went down on day X in the year X. Lo and behold, the certificate from the Royal Observatory stated that the sun went down at 21:3900 hours that day. Client got the lighter punishment for a regular break-in, not for a break-in at night. Story 47. I'm not a lawyer, but I once got out of a speeding ticket going over 100 miles per hour. I was pulled over by the sheriff and ticketed. Luckily, he let me go and didn't arrest me. I was given my court date and went to my arraignment and pled not guilty, and they set another court date for me to plead my case. Then I made discovery requests on everything I could think of: officer's notes, his whereabouts for the entire day, the service records of his vehicle, etc. This was quite a hassle because I had to write the request and send it to like 3 places: the sheriff, the court, and some records place or something. Well, of course, they didn't comply and sent me nothing, so I went to my court date and told the judge I can't possibly defend myself because my discovery request was not complied with, as is my right, and requested the court order compliance and a new court date set. Well, the judge obviously didn't like this, but he had no choice but to demand the sheriff's department to comply and send me the information I requested in discovery. So he set another court date, which I knew was outside of my speedy trial rights date. I told the judge I do not waive my right to a speedy trial and demanded an earlier court date. This really made him angry. He could not offer me an earlier date because the courts are overloaded and jammed up with other cases. He basically told me to screw off and they'll see me at my next court date. So the sheriff ended up complying with the court order and sent me a packet of information as I requested. Finally, my next court date rolls around and I see another judge. I made a motion to dismiss on the grounds that my speedy trial rights had been violated and I did not waive them, as many people do. The judge had no choice but to dismiss all charges, but not before lecturing me about the dangers of speeding. And if you learned a thing or two from any of these stories, here's more for you. YouTube thinks you're going to love this. I'll catch you in that video.